Again, my name is Allie Orwig, and I'm with the Indiana Rural Health Association. We're very excited to have our friends from Krieg DeVault here today to talk about a couple emerging topics we think are important for all of our members to know about. But before we get started, just want to remind everybody, you are welcome to ask questions throughout the session. We will hold those till the end, but you can do that via the chat function or the Q&A function. I'll keep an eye on both. Depending on which view mode you are in, those will pop down from either the top or the bottom. You should be able to submit those. If you would like, at the end of the session, we will open it up for questions, and you can use the raise hand function. At that time, I will be happy to unmute your line and you can ask your question verbally. But without further ado, I think that's all my housekeeping. I'll go ahead and turn it over to the Krieg DeVault team.
Great, thanks so much for that introduction. As Ali said, our presentation today is on some emerging topics here that are currently pending in the federal rulemaking process about a new provider type, rural emergency hospitals, and then some changes to the conditions of participation for critical access hospitals. So we can go to the next slide real quick. Just a brief disclaimer, the contents of this presentation should not be construed as legal advice or legal opinion. This is an informational presentation, again, on some rules that are pending and are not yet finalized, that are being implemented by CMS. So as these move forward, you're urged to consult with your attorney concerning specific fact patterns and the situation that you and your hospital may be facing in particular. So with that, we can move to the next slide and we'll do some brief introductions here. I'm Grant Achenbach, an attorney with Krieg DeVault. I joined the firm about a year ago. Prior, I practice in our government affairs practice group and our healthcare practice group. So a lot of my background on the government affairs side is in healthcare. Prior to joining Krieg DeVault, I was the director of government relations for the Indiana State Medical Association, and prior to that, in law school, worked for the Public Health Committee chair in the House of Representatives here in Indiana. And with that, I'll kick it to Megan and then Brandon for some brief intros as well.
Hello, I'm Megan McNabb. I'm a partner at Krieg DeVault. Been with the firm for about 10 or so years. My background is as a CPA practicing in nursing facility and hospital cost reporting, Medicare and Medicaid reimbursement. And I now focus on similar aspects, but on the legal side. So again, working on reimbursement issues as well as licensure, compliance, and other regulatory matters. Brandon?
Sure. Hi, everybody. Good morning. I'm Brandon Shirley. I've been with Krieg DeVault for 7 years. Most, if not all, of my practice is focused on healthcare regulatory, I call it. And that tends to fall in the Medicare, Medicaid regulatory buckets, but can expand to other areas, including compliance. So helping with compliance issues, fraud and abuse issues. So always plenty of work there to do. Thanks, Grant.
Thanks, Megan and Brandon. We can move to the next slide here. So our objectives and agenda for today, we're going to go into a brief introduction and kind of legislative history of the topics that we are dealing with today. As I mentioned, the subject matter is currently being implemented through the federal rulemaking process. So we will talk about kind of the status and the timeline regarding those rules. Then we'll jump into rural emergency hospitals, what that provider type looks like, including eligibility, the conditions of participation, coverage and reimbursement. We'll then provide an update on the conditions of participation that are changing for the critical access hospitals. And then we will wrap up with some notes on looking ahead and next steps and what you all can be mindful of in the future. So, and of course, after that, we're happy to take any questions. So yeah, thanks for advancing the slides here. So appropriate starting point for this discussion is, and I'm sure this is common knowledge to many on this call, but just to level set here, the history of critical access hospitals. Critical access hospitals were kind of started as a provider type in the 1980s and 90s in response to sort of this trend of rural hospital closures. So it was created in 1997 through federal legislation, and eligibility requirements for critical access hospitals include 25 or fewer acute care inpatient beds. There are distance requirements that we'll talk about kind of in more detail later in the presentation, but that dictate how far these hospitals have to be from another hospital. Again, they're intended to increase access to care in rural areas of the state or of a state or parts of the country where that may not be able to have access to care. They have to have an average annual length of stay of 96 hours or less and provide 24/7 emergency care services. And so eligible hospitals that critical access hospital designation carries with it several benefits, including reimbursement benefits, staffing flexibilities, other opportunities for technical assistance, et cetera. So we can move to the next slide now. And as these concerns about, yep, you can go ahead and jump to the next slide, please. So what we're talking about today are rural emergency hospitals, and these are a brand new provider type created by Congress in the Consolidated Appropriations Act of 2021. And really it is a similar policy in that it's an attempt to provide other options to critical access hospitals and rural hospitals in an effort to prevent further closure in these rural areas and to extend access to outpatient services, reduce health disparities in some parts of the state that may not otherwise be able to sustain a full service hospital. So the Centers for Medicare and Medicaid Services have begun the rulemaking process. CMS has begun the rulemaking process to implement this model. The Consolidated Appropriations Act gave CMS the authority to do so. And so that is all gearing up for when the statutory kind of start date for this new provider type, which is January 1 of 2023. And so during this whole rulemaking process to implement the rural emergency hospital model and provider type, CMS has also elected to update conditions of participation for critical access hospitals, which we'll talk about later. So next slide, we'll cover the status of the rule and the rulemaking process. So at a very high level, the federal rulemaking process requires a formal notice and comment period. This rural emergency hospital rule was published on, a proposed rule was published on July 6th of this year, which then started the public comment period, and those were accepted until August 29th of 2022. So now that comment period is closed, CMS is taking comments into consideration, looking at all the feedback from providers in the industry, and considering that feedback. And then the next step is they will release a final rule, which will be in all likelihood the final version of the rules to implement the rural emergency hospital model. So and that once that final rule is published, it'll likely be effective 30 days later. So with that, I will kick it over to Megan to discuss some more details about what exactly a rural emergency hospital is.
Thanks, Grant. If you want to go ahead and advance to the next slide, please. So as Grant said, the rule is still in the proposed state regarding rural emergency hospitals. And so while we're going to talk about some of the details of what these REHs look like, we're also going to talk about a lot of questions that are still outstanding at this point, kind of gaps in the language of the rule, gaps in the statute, and areas that we very well may see clarification either in the comments to the to the rule that are part of the final rule, or as additional guidance, or perhaps areas that are clarified when Indiana specifically addresses this from a state law regulatory perspective. So we'll get into the elements, but I'm also going to pose a lot of questions out there. So the proposed rule defines a rural emergency hospital as providing ED services, observation care, other outpatient services, and that the annual average length of stay is less than 24 hours. So kind of like a critical access hospital without the inpatient side. Specifically, the REH is not to provide inpatient services unless it's part, those inpatient services are provided in a distinct part skilled care unit that's really servicing the post-hospital extended care. I think this inpatient services is going to be a unique aspect when it comes to Indiana, because Indiana currently has a certificate of need process for skilled care beds. And so if hospitals are seeking to add beds, I think we're going to have to look at add beds for extended care. I think we're going to have to look at, does that trigger the CON law? Currently, a hospital is able to convert beds into like a distinct part extended care and avoid the certificate of need, but there are limits on the number of beds that can be converted. And I think that raises the question of if it's a rural emergency hospital that doesn't have inpatient beds, are there beds to convert? So what availability is there to provide these extended care inpatient services in Indiana going forward as part of the hospital? So I think there will be a lot of questions there as we continue to move forward. So then we also have the basic requirements of a rural emergency hospital. That is meeting the definition I just talked about, having a Medicare provider agreement, and then meeting the conditions of participation. Let's see. So some of the conditions of participation, some important ones. I think let's skip to the next slide here. One of the big elements is the state licensure requirement, and the rule requires that that the REH be located in a state that provides the licensing of such hospitals and either be licensed or is approved as meeting the standards for licensing. So this raises a question of what does it look like in Indiana in terms of, you know, future regulatory changes. It's our understanding that the Department of Health is in the process of promulgating rules that will address rural emergency hospitals in Indiana, and hopefully will be completed shortly after the new year. I think Grant might get into that a little bit more. So that's one big element here to look for, is how does this translate to the Indiana state law side? Some other conditions of participation are a transfer agreement with a level 1 or level 2 trauma center, meeting the emergency department requirements that also apply to critical access hospitals, and then making sure that ED is staffed 24/7. This is just a sample of the COPs. There's several other ones, but these are kind of the bigger ones we wanted to point out. I would also note there is a requirement for like the qualifications of a rural emergency hospital. It's not quite the basic requirements, but it basically says that CMS will certify a facility as a REH if, as of December 27th, 2020, the hospital was either a critical access hospital or a rural hospital with not more than 50 beds. And I think this again raises a lot of questions of what does it mean by 50 beds? Is that licensed beds, set up and available beds, average occupancy beds, cost report beds? Lot of clarification here needed. Also, you know, what if the hospital had beds on December 27th, had 50 beds on December 27th, and then added beds after that? What does that look like in terms of eligibility or if there was a closure in between. A lot of areas here that I think we'll probably see clarification on in the finalization of the rule. Next slide, please.
Hey, Megan, quick question. Do we anticipate, I don't know if you're going to get into this, Grant, but are there going to be needed any changes to the state law? Or can this all be accomplished through Department of Health? So, I mean, with some of the questions you were asking about certificates of need and other things, are these things that would need to be, addressed in the state law, or does the Department of Health, are they confident that this whole thing can be done in a rule?
So the Department of Health has indicated that they're promulgating REH rules. So in terms of that, it sounds like they're pretty comfortable that it can be done in rule. I have not directly talked to the Department of Health about considering the skilled nursing distinct part unit element of an REH and what that means in terms of Indiana's limitations on adding skilled beds. So I think that is something that we'll have to dive into more, and that it's possible that specifically addressing adding skilled beds in an REH may need to be addressed in law. But I think more conversations will be had in the near future on that aspect. Grant, is there anything you wanted to add to that?
Yeah, I agree. And yeah, that was something later in the presentation, but in the looking ahead section, but I think that fits well here since we were just talking about it. Yeah, because we have Indiana's hospital licensure law is ambiguous in terms of it doesn't strictly require a particular number of inpatient beds, which my understanding is that many states do put forth a standard for hospital licensure. And so with that being said, we understand that the department does understand or does feel that they need rules to implement the rural emergency hospital model. What we don't know are because this is all kind of happening in flux, we don't know exactly what the contours of those rules will look like yet, and kind of at the stages of discussing that and opening that line of communication. I think the rulemaking process here in the state obviously comes with its own state law requirements in terms of, its notice and comment period and review by the Attorney General's office and approval by the governor's office, and there's a whole process for that to take place. Whereas it's possible that the state legislature then meets starting in January of this year. They'll have a long budget session January through April. So I think that's it remains to be determined, if this is a kind of a pressing need, whether the legislature can jump in and speed up that process, or it is possible that, to Megan's point, as these conversations continue to evolve with the Department of Health, that in addition to recognizing the rural emergency hospital model in state statute, there may be other elements of state law, like the certificate of need, clarifying this inpatient bed question, that may pop up that need to be addressed. So that's a good question, Brandon. I think it is still a big question as these conversations evolve, but the good thing is, again, that the legislature will be in session for a period of time. We have seen there are other states that are beginning to address this legislatively. I think some have already passed or are considering bills that would add a definition of a rural emergency hospital state statute. So there's certainly basis for that, and it's popping up across the country. So
one more kind of topic on this rural emergency hospital before we kick it over to critical access hospitals and Brandon is the coverage and reimbursement element. This wasn't addressed in the proposed rule specifically. There will be rules forthcoming on what Medicare coverage and reimbursement look like for an REH, but we do know from this statute that they intend for REH services to be reimbursed at the same level as the hospital outpatient services, so the OPPS, plus 5%. There's also a monthly facility, a payment that will be made. So that's kind of the outline of what the Medicare reimbursement will look like, to be clarified in future rulemaking. But then there's also the question on the Medicaid side. We don't know what Medicaid coverage will look like, whether it'll be piecemeal coverage, kind of like on this Medicare side of an addition of outpatient services, or if there will be a bundled payment option. I think we'll probably see some guidance on that in the future, as well as Medicaid starts turning to what REH coverage looks like. All right, Brandon, do you want to start covering the critical access hospitals?
Sure. Next slide, please. I wanted to just make a few quick comments, just to make sure we're all on the same page on some things. When we're talking about rules and laws, they really are essentially one and the same. It's just how you get there that's different. So agencies pass rules, Congress or the legislature passes laws. And here we have CMS promulgating or drafting this rule and saying, here's how we want to make these designations. And Department of Health also doing the same thing regarding licensure. The benefit of the rule process, as Grant said, is it does allow for public input eventually. Once the rule is put in its proposed form, then you have a chance to comment on it. And that's the same thing that's going on right now with CMS's rule. One thing that we find really helpful, this is maybe just I don't know, it doesn't have to be just for lawyers to do, but something that can be very helpful for all of you hospitals is or interested parties is getting a hold of what CMS is proposing. Now, I think the current rule where they're putting all this in is about 55-ish pages. There's like 3 columns, so it can be longer reading. But getting that and understanding what their intent is, and as Megan, I think, said, or Grant, is at some point CMS is going to come out and say, okay, we've taken in all the comments we've received, and we're going to do our final rule. But before doing that, they say they have to address the comments that come in, and they'll say, somebody raised this question. This is how we're going to deal with that. Or this is our response to that question. Or we're not going to deal with that because it's outside the scope of what we're trying to do. So if you want to get a sneak peek into what exactly CMS means when they're doing these things, it's a really good idea to get that final rule and read through it and see how CMS is changing, how CMS is commenting and responding to people. I've seen it sometimes where CMS actually establishes kind of, and they shouldn't, but they do. They kind of set some new requirements out in their responses to people that don't go into the rule itself, but kind of become part of the narrative and understanding exactly how things are playing out. So I highly recommend you taking some time, and we do this too as a service to our clients, but we spend a lot of time understanding what CMS is doing, how they're viewing this, and through the comments and responses that everyone has provided on this. So some of the questions Megan raised, the gaps and things, maybe CMS will fill those with their responses to people's comments. They won't necessarily get into the rule, but at least you'll understand what's going on. The difference is that Department of Health won't do that. They won't publish all of their responses to agency people comments. They're kind of a statue when it comes to rulemaking. They just sit and listen, and then you don't really know what they're doing with that unless, as a service, they decide to say, well, here's how we're going to address all this, and they do some kind of communication. That's the downside of the state's rule process versus the federal rule process. So both should be watched and take full advantage of the process as we're moving into it, especially if you're interested in how licensing and all these questions that Megan raised is going to work as you move through, because that's what we would be doing. Okay, so circling back, critical access hospitals has been something, as Grant said, that has been a great benefit, I think, for most rural hospitals. And if there's questions on exactly what that means, I'm sure you can raise those, and maybe Megan has a better idea of the reimbursement side of it. But what I understand generally, as Grant said, is it's like 101% of reasonable cost, so that the Medicare reimbursement, rather than being like a prospective payment system, is going to be like cost-based. And so for some people, that's really good, especially rural hospitals. So there's an advantage of being a critical access hospital. What CMS has traditionally done for years is said, okay, you know, not everybody gets to do this. It has to be kind of really put into areas where there's a need, and especially rural areas. So sometimes you have categorical need, like if you're in a rural area, you can generally be okay. It gets a little more dicey as the more urban the areas get, and the more other hospitals kind of crop up in the area. Are you really a critical access hospital when somebody could drive 10 miles down the street and get the same care, right? So CMS has set up this system of rules, both in rules, as I said, rules meaning laws, and manuals. CMS is really good at churning out manuals because it's easy. And the manuals don't have to go through any sort of public comment and vetting. They can just issue the manual and it's there. The problem with operating by manuals is you don't always know how it's going to be applied. It can be changed without notice and comment. And so CMS has kind of walked this fine line between defining a critical access hospital, which is sometimes they've got stuff in their manuals, sometimes they've got stuff in their rules. What they're doing with the proposed rule saying, okay, fine, we're going to put it all in the rule because we need to get a tighter understanding and application of who's a critical access hospital. And so in tightening that up, you know, I think one of the drivers behind the need to tighten this up was an Office of Inspector General review that found CMS woefully inadequate in monitoring critical access hospital eligibility. It was a few years ago, but they essentially, the OIG, I call it the Office of Inspector General, the OIG issues this report saying, you know, there are so many critical access hospitals, they're you know, draining the Medicare fund. And CMS, you're not doing a very good job of checking this, of monitoring this. And, you know, some of them we think don't even meet the definition of a critical access hospital anymore. And CMS generally agreed that they could do a better job. The wheels of government turn slowly. So years go by, here we are today, where CMS is acknowledging, I think, some of what they're doing and saying, fine, let's tighten it up. How are they going to do that? Well, distance is one. So distance has been an easy way to figure out who's a critical access hospital, defining by roads, 50 miles or 35 miles we'll get into. But also, you know, when they check this, and I think for a long time it was just at initial determination, and then they kind of just let it lie. CMS is saying, fine, we'll be better at looking at this on a routine basis. Next slide, please. Okay, so in terms of the road thing, I think what CMS is proposing isn't going to be in terms of gauging distance between a critical access hospital and some other hospital. I don't think it's going to be a game changer, to be honest. You know, it really, what they're doing is, as I said, putting what they've done in manual into the rule. When looking at location, you know, you have to be no more than a 35-mile drive from another hospital, or 15 miles in a mountainous terrain with secondary roads. That's what the rule says. But, you know, they never define primary road. And this does matter depending on how you look at it. You know, it's like I remember, you know, some time ago when people would be submitting their receipts for like gas, and they're like, well, MapQuest says it was this. And so I'm like, well, if you use Google Maps, it takes you a different way. And you get, so it, in that sense, it can matter. It can affect your eligibility. So CMS is saying, we think it needs to be clearer what a primary road is when measuring distance between a critical access hospital and another hospital. So that's going to be put in code, really what it has been in the manuals for the most part. But that is still, what is a primary road? I think CMS is still inviting people to comment on how they've proposed that. So that's again going to be refined as the rule comes out. You can see what it is now, what they're proposing, but I wouldn't necessarily take it. I think CMS expects to change it based on what people are saying. Next slide, please. Yeah, so this gets to what I already said. So, you know, we can just move through to the following slide, please. Okay. The other way that CMS is going to tighten this up is being a little bit better, or I guess a lot better than what they've done in monitoring who is eligible to be a critical access hospital on an ongoing basis. So now they're proposing to, instead of, you know, look at it either at initial application or, you know, at some other point, they're going to be doing it every 3 years. And they're going to start by just basically drawing a 50-mile radius circle around a critical access hospital and saying what activity has happened within this 50-mile radius that will cause us to need to reevaluate this hospital's status as a critical access hospital. And they're going to be reaching out. In some instances, it will be automatic, like, okay, you know, you're fine. You get a pass, you move on, and others, they'll probably follow up and say with action saying, we are proposing to remove you because of what we found, and there can be some back and forth that may happen. But that will be kind of the big kicker with all of this increased enforcement, is that they're going to be monitoring that and I guess, so to speak, cleaning up. One final, I think, comment, and then I'll just say, you know, with a best practice is there's a necessary provider exception where if the state, your own state, has designated a critical access hospital as a quote unquote necessary provider, they are deemed a critical access hospital, but that had to have happened before 2006. So there's a grandfathering that happens that will continue from what I can see in this rule. They're not proposing to delete that or remove it. The OIG notably said of all the CAHs that we identified that shouldn't be a CAH, most of them were necessary providers, but there's nothing we can do about that because the states made them necessary providers and they're grandfathered in. So they're kind of protected by a bubble. So that doesn't appear to be threatened by the CMS proposed rules. But everyone else, if you're not a necessary provider, and I think most of you would know if you were, you should be looking at this rule if you're relying on the distance, especially if you're relying on the distance requirements, and saying, how is CMS defining distance? How are they defining primary road? Who's around us? Who's within 50 miles? Prepare yourselves in the event that, so that you're not surprised by a notice, or so that you can be thinking, if we need to make strategy decisions, we can be thinking of it now, because there's no indication that CMS is going to just let this rule sit and do nothing at all with it. I don't know if Grant or Megan, you agree, but it seems like it's full steam ahead from what I understand. Next slide. Okay, back to Grant.
One thing, can I just pop in here kind of on the full steam ahead? While we were talking, Brandon was talking about the benefit of reviewing the comments and CMS's response in the final rule, because that gets a glimpse into what the intent is and potentially some plans on how it's going to implement certain requirements that might not be in the rule itself. And I pulled up the number of comments that have been submitted. As Grant said, the comment period closed. So to date, there have been 3,800 comments submitted on this proposed rule. And as some of you probably remember, the infamous MFAR, which was proposed in 2019 and ultimately withdrawn, had only 4,000 comments. So we're pretty similar. So while it's full steam ahead, CMS has a lot of reviewing to do because, as Brandon said, they have to review all the comments. They'll probably batch them into categories to address them, but each of these will have to be reviewed and considered or addressed.
And Megan, can you tell what the comments are, or can you just see that they have been comments on it?
You can actually review the comments, and I will try to copy and paste the link into the comment section here so everybody can see. But there's even like a search function, and I typed in beds. And there's some questions about numbers of beds. I see references to cost report worksheets. So I think, we talked about the need for clarification around the 50 bed count. And I think people are asking for that. So I'll post this here so people can search to see what comments have been made on what topics.
Yeah, thanks, Brandon. Thanks, Megan. So jumping back in here, talking about looking ahead and sort of next steps. And I think we've, in one way or another, kind of referenced a lot of the points that we'll kind of conclude with here. But as we've talked about, the federal legislation requires rural emergency hospitals to be licensed in a state that provides for the licensing of such hospitals pursuant to state law. So as we covered earlier in the presentation, while there doesn't appear to be necessarily to be a statutory change regarding the lack of inpatient beds in the rural emergency hospital model, it remains to be seen sort of what the rulemaking, the Department of Health state rules will look like and what that process entails to determine if there need to be any additional statutory changes. Another element of that could be the certificate of need question that Megan raised about the extended care long-term beds that are recognized under the REH model. So that will be something to keep an eye on. We generally, as we've talked about, the notice and comment period has closed, and CMS is going to be reviewing those comments and making changes accordingly that will be implemented through the final rule. But it would be wise to, as Brandon said, kind of understand what the rural emergency hospital model looks like at a high level, so that you can determine whether that is an option that you may consider in the future, or kind of what circumstances could arise that would kind of push you to look at that more closely, and just knowing that it is out there. Again, the exact implementation, depending on, while the federal legislation allows for this provider type to start January 1, 2023, the federal rulemaking process has to be tied up, as well as if the Department of Health's rules will likely need to be finalized, or the legislature will need to act before we can know for sure what that implementation process looks like at a state level. And then finally, as Brandon just mentioned, reviewing the critical access hospital rule, whether your hospital relies on the distance requirements, and what that sort of renewed enforcement could mean for you. So with that, it would open it up to Megan and Brandon if we have anything else to add here moving forward. If not, we're happy to take any questions.
I think just a question, Megan or Grant, is there anything that a rural hospital could do today to say, well, we're really interested in becoming a rural emergency hospital? Do they just have to wait, or is there anywhere that they could start laying the foundation for that, or does it not make sense to think about that yet until later?
I think it's good to start thinking about it now. I've had a lot of hospitals reaching out to me, trying to explore their opportunities. A lot of these are in more rural counties, so it's exploring, does it make sense to wait this out to do the REH model, or should they look at maybe becoming a provider-based remote location or HOPD of a different hospital if they can meet the provider-based requirements. I think it's, exploring, do we really need inpatient beds? Do we want just minimal inpatient beds, or do we truly want to go outpatient and emergency? I'm seeing a lot of hospitals starting to explore that. So I think the conversation's happening now, particularly with the finance folks and figuring out prospective service lines and then the financial impact of them to really figure out which option could be used in the future.
Yeah, and adding on that, I've helped Megan. She and I have worked on some of these discussions about converting existing locations into other locations. And we have some very good checklists for you if that's what you're discussing. But I know from working with Megan that it's not as simple as, okay, next month we are going to be converted, or we will be this XYZ status. It's, it really is, what do we have to do and how much time? And there's notice that has to be given, and there's probably 50 levers that need to be pulled. So if a conversion or a downgrading of service lines or something is discussed, I highly recommend that you kind of forecast that out several months, if not a year, and saying, by next summer, we want to do this. So what do we have to be doing? And Megan and I said we've helped with that and could further assist with that. But it's more of a long-term planning, not kind of a let's hurry and try to get in line and get this done.
Yeah, definitely. And if there's construction that's going to be done, I know currently hospitals have a notice and hearing process that apply to certain construction over, I think it's $10 million. And to the extent an REH is considered a hospital under the statute, that process may apply. So again, that's just another thing that has to be considered as part of the long-term action plan on what steps need to be taken for any such conversion.
I did really quick see just a comment in the Q&A clarifying the cost reimbursement for critical access hospitals not being 100% of reasonable costs due to sequestration. So thanks for that clarification.
Okay, does anyone else have any questions? Again, you can use the raise hand function if you would like to ask your question verbally. And there is another question in the Q&A. Can you clarify what possible changes to the Indiana Department of Health is considering regarding the con and conversions to REH?
Regarding the conversion to an REH, we've heard that there's rules coming out regarding the CON. I think more conversations have to occur to figure out if there need to be changes and what those changes would look like. So I don't think there's much more clarification at this point, but I do think there's a lot more conversations to come and clarification to come.
But I do think to that question, right, Megan and Grant, that advocacy is, we're at a great point right now where if there's something you want, definitely get in front of regulators, like Grant, for instance, interfaces with legislators as part of his job here. So he advocates for our clients. If there's something favorable you want, let's talk. And for like me and Megan, if we want to submit a public comment to Department of Health in the rulemaking that is something you want, let's talk about that. We just heard from legislators yesterday that stopped by here, and we talked to them, and they rely on public input and lobbyists to explain what's needed. So definitely don't hesitate to reach out if there's a particular item that is beneficial or helpful while this rule is going through. It's better to get in front of it than have to try to fix it later.
Yeah, absolutely. And this is something, we'll be actively monitoring for the IRHA and others as there's more light shed on what these rules are going to look like as soon as there is kind of a public document circulated that is a starting point. We'll be kind of engaging before that to try to see if we can understand the general direction that they're going. But once there's something public, that'll certainly be circulated, and we'll be looking to you all for input and feedback to provide to state regulators, as well as if there is something that is determined to require statutory change. Again, the timing will be right because the legislature is coming into session starting in January. So your feedback and expertise is certainly helpful to all of us involved, and I'm happy to carry that in front of the proper regulators and legislators to help get that done. So thanks, Brandon.
Okay, well, I am not seeing any additional questions. We really appreciate your time today. A lot of good information. I've got everybody's contact information back up here now, so I'm certain the Krieg DeVault team would be happy to answer any questions you might have that come up later. Again, this session has been recorded, so we will have it up by the end of the week. And just again, appreciate everyone's time today.
Thank you.
Thank you.
Yes, thanks.